The supreme relief that's come in for Bilkis Bano, who's been fighting against the premature release of the 11 convicts who were granted remission by the Gujarat government on 15th August 2022. The Supreme Court has quashed the Gujarat government's order, saying that the state has no jurisdiction to pass any such order. It most certainly is a big verdict that's come in favor of Bilkis Bano, who's been fighting for justice for more than 1 year now. Remember, the 11 convicts were given freedom given the remission orders which were passed by the Gujarat government, and a big setback really coming in for the government with regards to the top court's verdict which was given earlier today. That remains our top focus story, with a lot of political exchanges also taking place over the same. But Times now has accessed the Supreme Court order copy in the case. The court has made some scathing observations against the Gujarat government, has mentioned that the exercise of discretion by the state of Gujarat is nothing but an instance of usurpation of jurisdiction and an instance of abuse of discretion as well. Before I quickly go across to Siddharth joining us with the copy, let me go across to Harish, who's accessed the copy for us. Harish, over to you. Take it away. Tell us about the top court's judgment and how do we really see the overall picture today, given the supreme setback that's come in for Gujarat government and most certainly a big breakthrough for Bilkis Bano in her fight for justice.
Yes, that's right, Christine. In fact, the Supreme Court goes on to say that to protect the rule of law, which is essential for the constitution to function in the country, these 11 convicts who have committed a very heinous, gruesome, horrendous offence cannot be allowed to roam around and must be put back in jail. And it goes on to say that to uphold rule of law, convicts must go back to jail and can't be allowed to roam free. Rule of law means whenever state fails to perform its duties, court would step in to ensure that rule of law prevails over abuse of process of law. Which essentially means that, Christine, it means that the Supreme Court questions and the circumstances under which the Gujarat government has usurped the jurisdiction of the Maharashtra government, and also supported the convicts who, according to the court, did not place complete facts before the Supreme Court, suppressed several facts, and also played fraud on the Supreme Court to get an order in May 2022, which was the basis of the judgment based on which Gujarat government had given remission to the convicts. Remember, as per the May 2022 judgment, the Supreme Court had said that it is the Gujarat government which is the competent body, appropriate authority to give remission, and also said that 1992 remission rules which allow release of rape, murder and gang rape accused is applicable, and not the 2014 remission policy which does not allow
this is big in
release
itself.
of gang
The
rape
court
and
saying
murder.
that the government of Gujarat was complicit with the convict, also saying this is a classic case of how order of the court was used to violate the rule of law. Siddharth is joining us with that detailed order copy of the top court of the country. Siddharth, over to you.
So, Christine, this is the operative portion, in fact, a summary of the conclusions of the judgment of the Supreme Court. On the one hand, it is actually said that the writ petition that had been filed under Article 32, this is by Bilkis Bano herself, is maintainable. Then it goes on to say that the other writ petitions in the form of PILs that have been filed by the likes of Mahua Moitra, among others, the maintainability of that is kept open to be adjudicated in an appropriate case later on. Then it comes to the main part, where it holds that the government of Gujarat had no jurisdiction to entertain the prayer seeking remission of the convicts, respondents number 3 to 13, as it was not the appropriate government within the meaning of the aforesaid provisions, that the right jurisdiction was under the state of Maharashtra. Thereafter, it therefore completely quashes the remission order that's been issued by the Gujarat government. It also says that the judgment that had been issued by the Supreme Court on the 13th of May 2022 is null and void and non-est in law, since the said order was sought by suppression of material facts as well as by misrepresentation of facts. So here's where it's actually pulled up one of the convicts, Radhesham Bhagwan Das Shah, who had filed that particular petition before the Supreme Court and that particular bench. It also said the above orders being contrary to the larger bench decisions of this court is per incurium and therefore not a binding precedent. Hence, the impugned orders of the remission dated the 8th of 10th of August 2022 are quashed on the above grounds. And thereafter, it also goes on to say in a later page that since the remission order, which basically allowed these prisoners to walk out of jail, was itself illegal and non-est in law, it's therefore incumbent upon those 13 convicts to eventually surrender to the prison authorities, and therefore they'll be back in jail. They've been given 2 months to in fact surrender before the police.
Okay, it's the nature of these observations from the top court that has today given ammunition to several political parties to directly take on the Gujarat government as well. Siddharth, many thanks for joining us. Let me quickly go across to Harish once again before I take in a word from Pragya and talk about the politics that's being witnessed as well. But Harish, like Siddharth just pointed out, the Supreme Court slamming the Gujarat government, also mentioning that it should have filed a review petition in the case against the Supreme Court order of May 2022, but it did not.
Christine, can you please repeat the question? It's not audible.
Just meaning to ask you about the Supreme Court, slamming the Gujarat government on why it did not file a review petition against the Supreme Court order, of May 2022, wherein it should have.
Yes, that's right, Christine. In fact, this is one of the ground in which the Supreme Court has slammed the Gujarat government, asking. Remember, Christine, what is important for our viewers is to know is that the May 2022 judgment is the basis on which the Gujarat government had given remission to all these 11 convicts. It is as per that. It is from that judgment that the Gujarat government had drawn power to usurp the jurisdiction, because that judgment said that Gujarat government is the competent government to give remission, and number two, it is that judgment which said that apply 1992 remission policy, which allowed release of gang rape, rape and murder convicts, and not the 2014 policy. The judgment said that since the 1992 policy held the field in 2008, that the day of the conviction, the 1992 policy will apply. So the Supreme Court essentially asked why the Gujarat government did not appeal against that order, which means that Gujarat government was complicit with the convicts. A very, very serious charge put forward by the Supreme Court, saying that the Gujarat government in a way has sided with the convicts who had got remission illegally by playing fraud with the court, and also not placing full facts before the court, and also suppressing various facts from the court to get a judgment in May 2022. And if the Gujarat government felt that that judgment is wrong, they should have filed a review and rather should not have sided with the convicts. They should not have been complicit with the convicts in this nature. That is why Supreme Court has pulled up the Gujarat government, saying that since the state has failed to reinstate the rule of law, we will ensure that all these convicts who had wrongly got remission, despite committing a heinous, horrendous, gruesome offense, they should go back to jail. Only then rule of law can be reinstated.
Okay, and a 2-week timeline has been set for the 11 convicts, all of them. Siddharth, I believe, wants to come in on some of the other points highlighted by the top court through this judgment copy.
To substantiate what Harish just told you a short while ago, Prithvi, here's the point of the order where it's pulled up the Gujarat government in a very serious way. Taking advantage of this court's order dated the 13th of May 2022, all other convicts also sought consideration of their case by the government of Gujarat for remission, even in the absence of any such direction in their cases by this court. Thus, the state of Gujarat has acted on the basis of the direction issued by this court, but contrary to the letter and spirit of law. Thereafter, it says, instead, the state of Gujarat has acted in tandem and was complicit with what the petitioner, respondent number 3 herein, had sought before the court. This is exactly what this court had apprehended at previous stages of this case and had intervened on 3 earlier occasions in the interest of truth and justice by transferring the investigation of the case to the CBI and the trial of the special court at Mumbai. Basically, in 2019, the Gujarat government had argued before the Gujarat High Court that the jurisdiction lies with the state of Maharashtra. So in 2022, when the Supreme Court came with a contrarian opinion that the jurisdiction lies with the state of Gujarat in this particular case and the Gujarat government may proceed, why did the Gujarat government, which had taken an opposite view in the previous judgment, not file a review petition? That's the question that the Supreme Court has asked.